The MMTLP resolution, goals, FOIAs, the data purge, and outcomes. A sober look at where we're at. Produced by Be the Boat Rocker. I'm Alan S. Billahus. Thank you for joining this presentation on the MMTLP resolution, goals, FOIAs, data purge, and outcomes. First, the primary goal should be trade settlement. This is about achieving full disclosure of all open MMTLP positions. That includes resolving short sales, addressing failed to deliveries or FTDs, and ensuring the proper distribution of NextBridge hydrocarbons shares or their equivalent value. Essentially, this would unfreeze the assets and provide resolution due to the halt's impact. Secondary goal is an audited share count. Here, we're pushing for independent verification of the total outstanding shares. This would incorporate data from the Consolidated Audit Trail, known as the CAT, for comprehensive trade tracking, along with blue sheets that detail broker specific transactions. The aim is to uncover any counterfeit shares or naked shorts, with community estimates suggesting over 10 million to 1 billion imbalances that point to potential market manipulation. Finally, the third goal is arrest and exposure. This focuses on holding them accountable, the key players involved, such as FINRA, the SEC, and officials, as well as brokers. These goals are interconnected, and as we'll see in the coming slides, tools like FOIAs are critical to advancing them, especially with the looming December 8, 2025 data purge. As we discussed in previous slide, our goals is trade settlement, audited share count, and arrest. With exposure requires solid evidence. This is where the Freedom of Information Act or FOIA requests come in. FOIAs are a powerful tool for uncovering hidden documents from government agencies like the SEC, FINRA. To date, MMTLP shareholders have filed over 30,000 such requests since 2023. But to make real progress, we need to target specific evidentiary gaps. This slide breaks down key FOIAs by goal, starting with those for trade settlement. Then we're looking for audited share count. Finally, arrests and exposures. This slide dives into the critical deadline that is looming for MMTLP shareholders, the so-called data dump on December 8, 2025. It's a pivotal event that could make or break our ability to achieve the goals we outlined earlier, as it directly impacts the availability of key evidence from FOIAs and other sources. First, what is the term data dump? Actually, it refers to the expiration of the mandatory 3-year retention period for essential regulatory records as required under SE Rule 17A 4 and FINRA's own rules. This period kicks off from the key dates of the halt and the final trading days, December 8th and 9th, 2022, which means by December 8, 2025, or shortly thereafter, all agencies, SEC, FINRA, and all the brokers can legally begin to purge records like blue sheets, CAT data, and fails to deliver logs, and all detailed trade records and communications. What it does, this expiration enables the legal destruction of evidence without triggering spoliation claims, unless a court order preserves it in advance, which hasn't happened. Yet, in practice, it erases concrete proof of share imbalances, open short positions, and potential market manipulation, effectively stalling any progress or audits or settlements. FINRA and the SEC can claim no records exist, in its response to subpoenas, FOIAs, lawsuits, significantly reducing the viability of any fraud cases now and in the future. Overall, it acts as a de facto endgame. SEC FINRA's immunity. Its strength is unbroken, its status is formidable, and post dump, it will never be broken. And you have to face the facts. So let's break it down. The formidable legal protections shielding the SEC and FINRA, and how the upcoming data purge on December 8, 2025 makes those defenses even stronger, as if they're not strong enough now. We'll go through the key points here, tying into why our goals for settlement, audits, and exposure faces steep odds, especially post-purge. Starting with the top, 12/8/25, MMTLP will be settled by the shredder, whether you want to believe it or not. This highlights the irony and frustration that will come on December 8th. The MMTLP saga might effectively be totally settled, not through fair resolution, but through the FINRA's own legal ability to shred the data. Under retention rules like 17A-4, records can be legally destroyed after 3 years. This includes brokers. This includes everybody that's included in this crime. Erasing the evidence of imbalance or manipulation and leaving shareholders with nothing but ends and odds and dead stories. Next, SEC denies 636,000 pages of FOIAs, 80% redacted, closed, now will be shredded. Exemptions for deliberative processes. The SEC has stonewalled over 636,000 pages of FOIA requests from MMTLP shareholders. 80% of those that we did get were heavily redacted or outright closed. They hid behind these exemptions. With the data shredder, they don't have to hide behind anything. FINRA's supplemental FAQ on November 6 of 2023 reiterates that there's no post-halt rights, stalls data release. Once the data's gone, then what do they have? They just get to say the data's gone. Back in November of 2023, FINRA issued a supplemental FAQ that doubled down on their position: no rights to post-halt trading or settlements for MMTLP shareholders. This has been the key stalling tactic, delaying data releases like blue sheets and further entrenching their unbroken immunity from lawsuits. Finally, the Department of Justice, FBI, RICO referrals have all been ignored. Ongoing probes as Perpetual shield. Shareholder referrals to the Department of Justice and FBI for potential RICO violations, racketeering, and organized crime angles has gone nowhere. They cite ongoing probes as a shield, which acts as a perpetual delay tactics, all for this end date of December 8, 2025, protecting SEC and FINRA from deeper scrutiny while immunity holds them firm. And once the data is gone, then there's nothing left for us. It's over. And no one seems to understand that. All right, assuming that you understand what we just went through, let's move forward to this slide. SEC FINRA immunity strength is unbroken. This slide builds directly on the data purge we just discussed, explaining why it's so hard to hold regulatory accountable. SEC and FINRA has the immediate immunity card, even with strong evidence from FOIAs and how the December 8, 2025 deadline makes their defenses even tougher to break through. Let's look at it. We're going to break it down section by section, starting with the core questions on this slide. How strong is FINRA and the SEC's immunity? FINRA, as a self regulatory organization or SRO, enjoys absolute immunity for regulatory acts like trading halts, even when they're alleged to be fraudulent or done in bad faith. Courts see this as a quasi governmental protection designed to let them oversee the markets without constraint of fear of lawsuits or illegal acts that they do. Meanwhile, the SEC holds sovereign immunity under the Federal Tort Claims Act, or FTCA, for discretionary functions, such as enforcement decisions. This bars most investor lawsuits unless it's waived through specific statutes like the Administrative Procedure Act, or APA. Together, this dual shield is ironclad for FINRA and the SEC. Let me repeat, this duel is ironclad. Do you not understand what ironclad means and what we're actually up against? There's no exceptions for fraud. There's no exceptions for you coming up and saying, "Hey, look, we caught you in this fraud." There's no exceptions. You have to understand what we're up against. It's ironclad. Key precedents back this up, like Standards Investment versus NASD from 2008, and more recent denials, such as the Supreme Court's June 2nd, 2025 refusal to hear Alpine Security versus FINRA, which fully upholds their ironclad protection. This strength is why our goals for audits, settlements, and exposure hit roadblocks. And we'll cover this next in the post dump scenario that makes it even worse and more formidable for us to achieve anything. The short answer is no. In fraud cases or otherwise, courts have consistently refused to pierce this immunity from FINRA and the SEC, even when malice, fraud, crime, or bad intent is alleged or proven. For example, there have been no successful challenges in the MMTLP related suits or in broader enforcement disputes from 2023 to 2025. Even the Supreme Court rulings like SEC versus Jarkowski in 2024, which do limit some of the SEC's powers in administrative proceedings, doesn't erode this immunity when it comes to defensive suits brought on by investors against regulators such as MMTLP. This unbroken track record shows just how entrenched the protections are for the SEC, FINRA, and brokers, making all more critical that we must act before the data purge amplifies them further. After the legal deletion of our MMTLP fraud data, SEC and FINRA will enjoy total freedom. This is just routine under the retention rules to delete this data. Defendants like brokers, the SEC, and FINRA can walk into court now claiming proudly that no data exists. It was legally purged. This shifts the entire burden back to MMTLP, NextBridge, you, the MMTLP shareholders. You have the burden of proof now, and no court will listen to you. And here's how it fortifies their already strong immunity. Without those records, any fraud claims becomes purely speculation. They get to call us liars. They get to call you freaks. All our claims will be labeled speculative, failing the strict, especially requirements under Rule 9B of the Federal Rules of Civil Procedures. Spoliation arguments claims that evidence was wrongfully destroyed will fall flat because the deletion wasn't proper. It was legally done. It was allowed by the rules. As a result, cases will get dismissed much easier than we have seen in the past for MMTLP, turning those strong immunity shields into imperturbable ones. Ultimately, the evidence gaps dooms our pursuits for any audits, settlements, or exposure, making the December 8, 2025 post game changer in the worst way. This reality emphasizes why time is of the essence. If you want to win trade settlement, you need to figure out how to overcome this. Otherwise, this is the end game. No more. This slide examines the hypothetical but risky scenario for MMTLP shareholders. What happens if the efforts are limited solely to FOIA requests after the December 8, 2025 data purge? It ties back into everything we've covered: the goals, essential FOIAs, the purge itself, and the unbreakable immunity of SEC and FINRA, showing why a narrow focus could lead to dead ends. Starting with the scenario, this assumes exclusive reliance on FOIA and gathering evidence, such as aggregating responses after exposing inconsistencies, but without pursuing lawsuits, congressional subpoenas, or state probes like the Missouri ongoing demand. Now, the likely outcome: no trade settlement. Let me repeat: no trade settlement means no money. And with only a 0 to 5% chance post purge, as the data gaps from deleted records doom specifically needed for any legal claims. An audited share count would stall out, with FINRA resisting releases and dismissing them as burdensome. Arrests and exposures would be minimum. Redacted documents might fuel some kind of narrative on social media or in the community, but they lack the enforcement teeth to drive real action. In the end, it leads to perpetual limbo. Basically, what we've had for the last 3 years: perpetual limbo. The 1,051 days of halt inaction extends indefinitely. The game is over. NextBridge hydrocarbons share value will absolutely hit zero, and regulators walk free, hiding behind the no records exist defenses fortified by immunity. This scenario really drives home the need for a diversified strategy. FOIAs, yes, are valuable, but not alone, and not with this date looming. They're not enough to break through the post purge issues we will face.